Good evening. It's close to 0 degrees Kelvin here in New York today, so I thought it might be a good time to talk about an interesting case which was discussed in the January 24th edition of the New York Law Journal, January 24th, 2014. And the case is Estate of Thomas out of Bronx County Surrogates Court. There are different items going on in this case, but what I wanted to focus on was, in particular, the decedent took a pen to his original will and changed it substantially. In fact, in this case, the decedent, who died in the year 2000, October 29th of 2000, at the age of 91. So the decedent died 14 years ago, just about. And the case is only now coming through the probate system, even though he died in the year 2000. The will was drafted in March of 1994. So the decedent was 84 years old at the time. Nevertheless, between the time that the decedent's will was drafted in 1994 and when he died in the year 2000, the decedent had taken a pen and marked on his will. The original will, which was 7 pages long, contains 29 separate bequests to persons or charities. It's not quite clear in the opinion who were the beneficiaries of the will, but there were 29 separate pre-residuary bequests, and of those 29 bequests, 25 of them were changed by the decedent while he was alive, so he was a testator, were changed by the fella with a pen in some significant ways. Then the decedent died. And so the question before the court was, well, what do we do with the will? Do we accept the will and give the decedent's handwritten changes effect? Or should we admit the will as it was signed back in 1994 and just forget about those changes which the decedent made in pen? So what do you think the answer is? Well, the answer is that those changes have no effect. And in fact, this will ended up being admitted to probate in its original form as signed in 1994. The court gave no effect to the handwritten changes which the decedent made to his original will. And so that is the law in New York. New York is very strict with respect to the formalities of executing a last will and testament. Very strict. Those formalities of signing before 2 witnesses, the witnesses signing together, the testator declaring, this is my last will and testament, and asking the witnesses to, in fact, be witnesses on the will. Those are among the formalities which New York is very strict on. And because these handwritten changes were made without those formalities, the court had no choice but to ignore them. And this sort of cuts both ways, meaning you might be able to say, well, obviously the man intended to make these changes, cross out certain people, or increase the bequests he was making to certain people or charities, or decrease the bequests which he was making to other people. Obviously, that was his intention, right? Well, maybe not. Maybe he was just making remarks on his will that he wanted to speak to his lawyer about at some point. And he never really had an intention of making a new will. So it goes both ways. This was either the man's intention, or maybe it was just something he had in mind and he never intended to have these changes be part of his will because he never actually called his lawyer and said, look, I want to draft my will over again. So an interesting case out of Bronx County, state of Thomas, 757A of 2004/A, estate of Thomas. Okay, so I thought that was interesting and useful. Good night.